What are those big questions that all clients want to know from their divorce lawyers? That's what we're talking about today. I'm John Henderson, and this is HH Law. All right, today we're talking about the questions that all clients want to know from their lawyers. We've actually are joined today by Holly Roberts, one of our attorneys, and David Dunlavey, another one of our attorneys. And we're going to chat about some of the issues that come up quite frequently that clients need to know right out of the gate. The first one, how much is all this going to cost me? And I'll take that one since I handle a lot of the financial aspects of the law firm and collections and that sort of thing. The answer is it depends. And that's the answer most of the time with these things is that it depends. It could be $5,000. It could be $50,000 on up, and it depends on a number of factors. But typically we find that most divorces are going to cost, in your legal fees on your side, at least $10,000. A lot of firms will do a $5,000, $6,000, $7,500 retainer on the front end of that. We hold that money and we pay ourselves along and along, and then you refresh as you go along and along. And David, what are one of the issues that would really drive up the cost of divorce litigation?
So one of the issues that really drives up costs in any of these situations is, first of all, kids being involved. If you have a divorce where kids are involved, there's going to automatically and naturally be more issues to sort out. There's a little more gray area to sort out. There's a little more freedom to sort out instead of who pays what bills in this intermediary period. There are a lot of costs associated with cases that aren't necessarily just your attorney's fees, whether that be mediation where you're paying the mediator as well to help facilitate an agreement, or a guardian ad litem. The guardian ad litems are there to protect the children and look out for the best interests of the children, and that is a cost outside of just your attorney's fees that sometimes we run into, whether that's unexpected or that's something additional that you can't expect in these cases that involve children.
Holly, what would you add to that?
I would add, if there's a plethora of emails coming in, we are required to review them. That will be a charge to the client for reviewing and responding to the emails. So I would say emails really drive up the attorney's fees as well.
And calls. We had a call, one that I think I reviewed over 100 emails and multiple calls a day in the first month, and that really drives it up. All right, so that handles the cost. Next question that we get a lot is, how long is all this going to take?
You know, there's not a definite timeline for a divorce or a custody action, but there are some thresholds in terms of, there's two types of divorce in South Carolina. There's a fault and a no fault. The fault grounds, if you're bringing a divorce on those grounds, there needs to be 90 days elapsed from the date of filing before the court can issue that divorce through a final order. The no fault grounds requires you to be separated for a year. So if you come to us and you're like, David, I've been separated from my husband. I moved out last week. We'll get the case going, and there's lots of things we can do in the interim. But the court is not going to issue that final decree until you have been separated for a year. There are lots of steps along the way that prolong or shorten a case. One of the big steps is coming to an agreement. Whether they're able to come to an agreement or not and how long that takes is a big driving force into how long the case lasts itself. But there are those 90-day and 1-year thresholds for the official final divorce in any case.
And Holly, do you find that time can help with a resolution? In other words, sometimes people need 6 months, 9 months to let the anger subside before they can get there. Can it be an advantage, in other words?
Absolutely. I think it could be an advantage. The parties can come together. They can work towards a settlement agreement. They can let some of those tensions and high feelings that they have for their other partner, kind of subside a little bit. It can also help on the financial side of it. For example, if one party is buying out another party from the marital home, it gives them time to refinance the mortgage, figure all of that information out. So I do think there is an advantage in some cases with regard to waiting the time out a little bit.
Yes. And Holly practiced previously in Chicago, Illinois. So Holly, tell us, what's the difference in that time frame between David's reference South Carolina law? Is there a different time frame in Chicago and Illinois?
Yes, there is a different time frame. So in Illinois, what the court does is you can get a divorce on any grounds. Basically, it's a no-fault divorce state, and all you have to do is file a complaint, and within 90 days, you can be divorced. There's no 1 year required separation for the parties to be living separate and apart for a no-fault divorce. As soon as you can get an agreement, the court, so long as the court approves agreement, will issue you a divorce.
Okay, so and that reminds us that what we're dealing with mostly is South Carolina law, but it shows us a little bit of the differences between the states and why it's so vital for you to contact a lawyer in your state to try to get exact state-specific information. Moving on to the next question that we get all the time. It's about custody. Who is going to get custody of the children? What are some of the driving factors, David?
The custody of the children, there are a number of factors. The one prevailing phrase that you will hear if you're involved in any of these cases is best interest of the child. These factors the court considers as far as school, as far as education, as far as who has been there handling the day-to-day activities of the children as they've grown up, are all factors the court will consider in this. And also, it's considered how you co-parent together, how you work together. Are you willing to do that? Can you do that if you maintain primary custody of a child? There's a number of factors that are in our code and judges consider when making these decisions, and one of them does not trump the other one. They're considering all of them of who can provide for their family, who can provide stability. All those different things are considered in a custody matter.
All right, and Holly, we'll come to you on child support. So if there's a child issue, if there's a child involved, David has outlined exactly what's going on or some of the issues going on with who's going to have custody, but then the other party might be paying child support. What are those circumstances?
So the circumstances for child support, the court is going to consider both parties' incomes, and it's basically a formula that you plug and chug each party's incomes into, and it also considers each party's overnights with the children.
If I recall, we've also got some other factors in there as well. What about daycare and that kind of thing?
Correct. So daycare, the children's extracurricular activities, those will also be involved. And then each party typically is responsible for the children's incidental costs and expenses while the children are in that party's care.
And then these things are modifiable. David, what happens when now there's no more child care and then they're going to school and maybe somebody's income has changed substantially? What are the factors where we might change those?
So child support, as you can imagine, lives change. Your income changes. You get a new job. You get fired from a job. Income changes, and then child support is mainly income driven. There is a threshold for the court considering changes in child support. That's why it's important to contact us, do it the right way, do the correct filings, and get it done as expeditiously as possible without you running around with the court and figuring out what's filed. But if your income changes in a certain way, you can certainly go in and modify how much you're paying per month, how much you've previously owed. If you're owing a bunch, we can handle. You can come in, you can figure that out with the court as well. Don't feel kind of like you're stuck there. There's ways that we can not get around it, but come to agreements or arrangements with that as well.
So moving next to the big one for a lot of couples. The scenario is that they bought a house together. We're not going to deal with having a house prior, but who is going to get to stay in the house? What are we doing with the equity in that home? David, lead us through this.
The home is oftentimes one of the biggest assets we're talking about in a case, and not a lot of people own their home outright, so we're dealing with mortgages, deeds, who's on the mortgage. Ultimately, a lot of questions I get too are, I'm on the title of the house or not on the title of the house, he is on the title of the house, or she's just on the mortgage. Those factors are not deciding factors in whether that house is going to be yours or his. It's considered a marital home. If you guys lived in it during the marriage, you use that as your main residence. But there are typically, I like to say, 3 options with what's going to be done with the house. Someone's going to either buy someone else out of the house, whether that be the husband buying the wife out or the wife buying the husband out. Those are kind of the 2 options. Or we're going to sell the house. If we're disagreeing on price, I can tell you now the Price is going to be decided. If we can't figure it out, the court's going to say, let's sell it. That's going to be the price. But there are options to the house. You're not going to be stuck with the house if you don't want it. You're not going to be forced to buy out. But there are also the aspect of buyouts, of refinancing. We can help you through that as well with the bank and extend periods of times and allow that. But those are kind of the three ways the house gets decided as a final resolution in a case.
And let's round this out with a good one for Holly. Holly, should I file first? We get this all the time. Should we beat her to the punch?
There are some slight advantages to filing first. For example, if you file first, you're the one filing the complaint. The court is going to hear and see your side of the divorce before they hear your spouse's. Also, you get to control the narrative. So there is some slight advantage to filing first.
Okay. Thank you, David. Thank you, Holly. We appreciate you joining us for this video. Any questions that you have, if you're in the state of South Carolina and you have questions about divorce, custody issues, any family law issues, we are happy to address those and talk to you. If you're not in South Carolina, contact a lawyer in your local state or in your jurisdiction for more information. I'm John Henderson, and this is HH Law.